You all hear me at Conti? And what about North Broward? Great. Good morning, everyone. We are here for your probable cause hearing. Let me explain to you what that is. What that means is that it's my job to determine whether or not there's probable cause to hold you. You're entitled to this hearing within 24 hours. If I find that there's probable cause to hold you, I'm going to tell you what the bond is. Just so you know, if it's a misdemeanor, there is a possibility that we'll be able to resolve it today. The misdemeanors that we cannot resolve today are batteries and driving under the influence. However, you need to know if you're charged with driving with a suspended driver's license. If you get 3 of those, you're going to lose your license for 5 years. If you choose to plead to a petty theft and you get 3 petty thefts, they can start charging you as a felon. The Public Defender's Office is going to represent you during this hearing. If you don't want them, just let me know. If it's a municipal ordinance, there is not a lawyer there to represent you. However, if you want one, I'll get one there for you. So when I call your name, if you would step forward, I would appreciate it. And hopefully I can at least tell you what you've been charged with, and inform you of the bond. Linda D. McGee. Where's Miss McGee?
I believe she's in the main jail, Judge.
Thank you. Mr. Romero, good morning, sir.
Good morning, Judge.
All right, Miss McGee, it looks like there's an out-of-state hold for you for a felony. Court finds there's probable cause, no bond. Stephanie Rose Gladstone.
North Broward. Ms. Gladstone has indicated she has private counsel.
All right, Miss Gladstone, just so you know, you've been charged with resisting arrest without violence, 2 violations of probation. The court finds there's probable cause. Bond is set in the amount of $100 on count 1. The 2 violation of probations are no bond hold. Kimberly Jean Berga.
She's in Paul Ryan. Should like to resolve this if
Okay.
possible, Judge.
Counsel for the state, Priors.
Hold that right now, Judge.
Okay. Ms. Berga, good morning. There's a warrant out for your arrest. It was for prostitution. Bond is set in the amount of $300. Hang on one second, okay?
She had a prostitution on April this year, Your Honor. Fled out. Another one in March of this year. Another one in 2016. Petty theft and a trespass, 2015. A petty theft, 2015.
All right, ma'am, if you want to resolve this, the offer from me is 15 days in the Broward County Jail. You're going to be adjudicated guilty. You have to get an HIV STD test. You don't have to tell anybody the results. If you do not want to do that, you just need to post bond in the amount of $300. Tell me what you want to do.
Nothing to do with anything.
And you have a hearing Friday at 10 o'clock in front of who? In front of Judge Levy-Cohn. So tell me what you want to do. I can set this in front of Judge Levy-Cohn if you want on Friday.
So I'm either here till Friday, post bond,
Well, it sounds to
or
me,
you.
I don't know what the case is on Friday, whether you have a bond or that or not. I just don't know the answer. I can just tell you about this one. I'm telling you have a hearing on Friday.
In no way I can get time served.
No.
Judge,
Not for me.
Ms. Berg indicated to me, Judge, all she really wants to do is go back to Ohio.
Well, why don't we put this in front of Judge Levy-Cohn at 10 o'clock on Friday? Maybe you can resolve them both then, unless you bond out.
You know, you might be better off doing that, Ms. Berga. That way maybe Judge Levy-Cohen will time serve you on Friday as opposed to taking a 15-day offer today.
Okay.
Okay?
All righty.
All right, good luck.
Good luck to you, ma'am. Tamara Demps. Ms. Demps, good morning.
Good morning.
Ma'am, there's an out-of-county hold for you, and there's a violation of probation. Court finds there's probable cause. No bond on both of them.
There is a bond on count
Is
2,
there?
Judge.
It's 500 on count 2. Emanuela Pierre.
I see it
No,
as 13,500.
All right. Hang on, folks. $13,500. No bond on count 1. You're up. Emanuela Pierre.
She's your president, Major.
Good morning.
Good morning, Miss Pierre. You've been charged with a violation of probation. It's a felony. Court finds that there's probable cause. No bond. Rebecca Strobridge.
North Broward.
Good morning.
Ma'am.
Hang on. Let me talk to you first, okay? You have a violation of probation, which is a felon. Hang on. which is a felony, and then there's a burglary of an occupied conveyance unarmed. Court finds there's probable cause. No,
I'm not on probation.
Judge, I'm not sure she is on probation. I've been looking at this case. Rebecca, give me a minute, okay?
Yes, sir.
It looks as though there was a capias issued for her on June 9th of 2017 for a failure to appear on this case, 1700308 CF10A. But I don't see where she's ever been sentenced to probation on that.
Counsel for the state?
Yeah, Your Honor, she was just booked incorrectly. The capias is okay.
Okay, it should be a capias on the felony, not a violation of probation. Is there a warrant on that? Is there a bond on that capias?
No.
All right, no bond on count one, $1,000 on count two. So it's not a probation, you're not on probation, it's just a warrant because you didn't show up for court, I guess.
Is there any way I can be ROI for because they have the wrong person. They
All right.
looked at my arms. You see it
Don't
all-
discuss the facts of your
All right,
case, Ms. Strobridge.
we're gonna get you in front of the judge that has the case, okay? You're set to be there on 6/20. Thank you.
So I have to wait all the
Was
way
there-
till then?
Yes, ma'am. Jade Alexander Williams.
I'm sorry.
Judge, I'm going to ask on Ms. Strawbridge that you sign an order allowing our office to take photographs of her because I think they might tend to show that she is not the person they're looking for on this burglary.
That'd be great.
Your Honor, I apologize. What was the bond on count two? On Ms.
1,000. Jade Alexandra Williams.
Thank you.
You're welcome, ma'am. Good morning. Ma'am, you've been charged with grand theft. I find that there's probable cause bond is set in the amount of $1,000. Sure. Sure. So here's what we're going to do. If pretrial can verify your address, I'm going to ROR you, okay?
Okay.
All righty. If not, you can still bond out for $1,000. Okay?
Okay.
All righty, ma'am. Joanne Kathy Burnell. All right. Good morning. Ma'am, you've been charged with possession of cocaine, possession of drug paraphernalia, tampering with or fabricating physical evidence, and there's a misdemeanor capias. Court finds there's probable cause. Bond is set in the amount of $1,000 count one, $100 count two, $1,000 count three, $100 count four. You're welcome.
All right, I'll make those calls for you, Joanne.
Tania Rubio.
Judge, she's going to require a Spanish interpreter.
Okay, let's put it on recall.
I've already ordered one, Judge. They
Thank
should
you.
be here shortly.
Alexis Rayonte Amon Jackson.
Ms. Jackson,
We in Maine?
yes.
All right. Good morning. You've been charged with possession of cocaine. Court finds there's probable cause. Bond is set in the amount of $1,000. Morel Auxiliaire.
North Broward.
Good morning. Sir, there's a violation of probation for a misdemeanor for your arrest. Court finds there's probable cause. No bond.
May I speak?
If you want to,
Do you
but
want to try and resolve this morning, Mr.
here's-
Morell?
Well, wait. He's just so you know.
Let's look into that if we can. Hang on, don't say anything else.
Just so you know, I've got a warrant. He was placed on probation, driving while license is suspended, allegedly violating by trafficking in phenethylamines, possession with intent to sell. I don't know that he should
All right, I don't
resolve
think
it.
we can resolve this today,
Okay?
sir.
I just don't think that's a good idea. You're welcome. Dwayne Alfonso Schneider.
Yes, I want.
Mrs. Schneider.
Yes.
Good morning, sir. Sir, you've been charged with trespass. Court finds there's probable cause. Counsel for the defense.
Judge, she's inquiring if Your Honor would consider resolving this.
Counsel for the state. Priors.
Yes, just to advise the court, Mr. Schneider. 2015 out of Broward, strong arm robbery and aggravated battery. Year in a day state prison. I guess he pled it out on March 30th and already had his time served at that time. Prior arrests, Your Honor, out of the Virgin Islands, don't have disposition on the most recent.
I'll give him time served, but he can't go back to the parking garage. Want to do that?
Yes.
Raise your right hand.
Yes.
Raise your right hand. Do you solemnly swear the testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I swear.
Put your hand down, sir, and please tell me your name.
Dwayne Alfonso Snyder.
It's my understanding, sir, you want to change your plea from not guilty to no contest. Is that right?
Yes, ma'am.
Anybody forcing you to do that?
No, ma'am.
Anybody promise you anything to get you to do that?
No, ma'am.
Sir, are you under the influence of any alcohol or drugs so you don't understand what's going on here today?
Nope.
Understand if you're not a citizen, this plea will subject you to deportation.
Yes.
I find that it's a knowing, intelligent, and voluntary waiver, factual basis based on the probable cause affidavit. At this point in time, you're going to be adjudicated guilty, sentenced to time served. Court cost of prosecution are going to be imposed. I'm going to give you a year to pay. You can't go back to that parking garage, okay?
I know.
All righty, good luck to you. Patrick,
Okay.
Patrick Wells.
Mr. Wells is here present.
Do we have a driving? Hang on a second. Mr. Wells, you've been charged. There's a warrant out for your arrest for driving with a suspended driver's license. I find that there's probable cause. Mr. Romero, if he wants to resolve this, I'll adjudicate him and give him time served. This would be his first.
Sure. I was in the hospital too. That's why I got to go too.
Okay, well, all right, it's up to you. If you want to go ahead and resolve the case today, the court's offering you a time served. If not, you go ahead and postpone. What would you like to do? So then let the judge know that's what you.
What do you want to do, sir? Raise your right hand. Raise your right hand. Do you solemnly swear the testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
Yes.
Put your hand down, sir, and please tell me your name.
Patrick Wells.
Mr. Wells, it's my understanding you want to change your plea from not guilty to no contest. Is that right?
Yes.
Anybody forcing you to do that?
No, ma'am.
Anybody promise you anything to get you to do that?
No, ma'am.
Sir, are you under the influence of any alcohol or drugs so you don't understand what's going on here today?
Yes, ma'am.
Understand if you're not a citizen, this plea will subject you to deportation.
Yes, ma'am.
I find that it's a knowing, intelligent, and voluntary waiver, factual basis based on the driving record and the ticket. At this point in time, you're going to be adjudicated guilty, sentenced to time served. Court cost of prosecution are going to be imposed. I'm going to give you a year to pay. Sir, good luck to you.
Thank you, ma'am.
You're welcome. Tanya Rubio, that was the person that needed the Spanish interpreter, right? She's here.
Yes.
Good morning, ma'am.
Señora.
Listen. Good morning.
Buenos días.
Buenos días.
Good morning.
Ma'am, you've been charged with criminal mischief
Le han acusado de daño a la propiedad
and resisting arrest without
y
violence.
resistir al arresto sin violencia.
I find that there's probable cause.
Encuentro que hay causa probable para el cargo.
Pre-trial. Okay. State priors.
Priors, Your Honor.
Que usted no tiene antecedentes.
Bond
dice
is
la
set in the amount
fiscal.
of $500 on count one.
$500 le van a cobrar de fianza por el primer
$250
cargo,
on count
250 en el segundo cargo.
Good luck to you, ma'am.
Que
Dante
tenga buena
Harris.
suerte.
If the defense could be heard, Judge.
Sure.
What you do?
My understanding is
Consider bond.
Ms. She's 47 years old. She's currently employed. She works at Gulfstream as a trainer. She just got the job. She lives in Hallandale. She lives in a trailer with her and her boyfriend. Unfortunately, when she was arrested, her phone was not in her possession, so she has no contacts, no one to post her bond. Her boyfriend is an electrician that, because of employment, he's out of the city for like a week at a time. So currently, he's not there for a whole week. So she has no one to contact. The only exigent circumstance that exists, normally she could pay this, but her boyfriend's not around. She'd be willing to wait, but unfortunately, she has a dog, a terrier. The terrier is in her apartment by himself. Considering this is a nonviolent offense, Judge, considering I believe there's no serious record or anything like
Considerando que esta cargo no es de violencia,
I would ask you to
le está pidiendo considerar.
I would ask you also if you wish to impose pretrial for it to be standard and not
Y que si quiere imponerle una anterior al juicio, una clase anterior al juicio, pre-trial,
it delays the process as far as verification.
eso demora la verificación,
Okay,
I mean, you could
el
order
proceso.
call in 3 times a week, report in person.
La jueza que ella puede pedir que se reporte 3 veces por semana.
okay, at this point in time, your
En este
request will be
momento,
denied, but
Esa
I will,
solicitud está siendo negada,
pretrial can verify, I'll put her on pretrial.
pero la va a poner
Pending
en pretrial, en el programa pretrial siempre y cuando haya una verificación antes de darle el programa.
And I apologize if you already did. Did the court order no victim contact?
No victim
También
contact.
quiere que imponga que usted no tenga contacto con la víctima.
Dante Harris,
Thank you.
you're welcome. Good morning, sir. Sir, good. Sir, you've been charged with possession of drug paraphernalia and trespass. I find that there's probable cause. Counsel for the state, Priors.
1 moment, Your Honor.
I didn't have any drug.
Hang on, hang on.
Don't
Shh,
don't say anything, sir. Just hang on for 1 second, okay?
So recent. Your Honor, I'm showing. He was arrested just about 5 weeks ago on a felony. And that was possession of cocaine and trespass. State has not filed charges. He was ROR'd he was released this past Saturday in ROR.
Okay. Mr. Reedy, if he wants to resolve this, I'll give him time, sir. Give him time, sir.
Want time served, Mr. Harris? Mr. Harris, do you want time served?
Raise your right
Enter,
hand.
enter a plea of no contest. You can have time served.
All right. Do you solemnly swear the testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God? Put your hand down, please. Tell me your name. Mr. Harris, it's my understanding you want to change your plea from not guilty to no contest. Is that right? Anybody forcing you to do that? Anybody promise you anything to get you to do that? Sir, are you under the influence of any alcohol or drugs so you don't understand what's going on here today?
No.
Understand if you're not a citizen, this plea will subject you to deportation.
Yes.
I find that it's a knowing, intelligent, and voluntary waiver. Factual basis based on the probable cause affidavit. At this point in time, you're going to be adjudicated guilty on counts 1 and 2. Court cost of prosecution are going to be imposed. I'm going to give you a year to pay. You got to quit panhandling in that area, okay?
Okay.
All righty. Good luck to you.
So I have a time served.
Time served. You're out. Okay. Good luck to you. Orlando Don Henry. Good morning, sir. Sir, you've been charged with resisting arrest without violence. I find that there's probable cause. Counsel for the state. Hang on. Counsel for the state Priors.
Yes, Judge.
Okay, hang on.
February of this year, you had a trespass. 2016, a trespass. 2010, driving under the influence. 2008, battery on a Leo, obstruction without violence. Obstruction with violence, sorry.
Counsel for the defense, if he wants to resolve it, I'll give him time served.
Would you like to resolve this for time served, Mr. Henry?
All
wanna
right.
bond out?
Bond is set in the amount of
Okay.
$100. Brandon David Ross.
Mr. Ross is here present or remain?
Mr. Ross, good morning. You've been charged with trespass. I find that there's probable cause. Counsel for the defense, does he want to resolve this?
Mr. Ross wishes to ask the court to issue a contract today.
Of course I will. Raise your right hand. Do you solemnly swear the testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
Yes.
Put your hand down, sir, and please tell me your name.
Brandon David Ross.
Mr. Ross, it's my understanding you want to change your plea from not guilty to no contest. Is that right?
That's right.
Anybody forcing you to do that?
No.
Anybody promise you anything to get you to do that?
No.
Are you under the influence, sir, of any alcohol or drugs so you don't understand what's going on here today?
No, Your Honor.
Understand if you're not a citizen, this plea will subject you to deportation.
Yes.
I find that it's a knowing, intelligent, and voluntary waiver, factual basis based on the probable cause affidavit. At this point in time, you're going to be adjudicated guilty, sentenced to time served. Court cost of prosecution are going to be imposed. I'm going to give you a year to pay. You got to stay off that overpass. You hear me?
Yes, ma'am.
Okay, good luck to you. Baliwa Nakinji Davis.
Mr. Davis, come on up, please.
Mr. Davis, you've been charged with touching or striking, battery, or domestic violence, contempt of court. I find there's probable cause. Bond is set in the amount of $2,500 on count 1, $2,500 on count 2. No contact with the victim.
Your Honor,
Tasman,
I just asked, with regard to the no contact, that it also include the standard conditions of a domestic violence no contact order?
absolutely. Standard conditions of the domestic violence, no contact. Tasman Joseph Forsythe.
Mr. Forsythe, come on up, please.
Mr. Forsythe, you've been charged with battery. I find there's probable cause. Bond is set in the amount of $1,000. No contact with the victim. Maziel Angel Vargas Reynoso.
Mr. Vargas, Judge of Municipal Ordinance, please.
Yes. Sir, you don't have a lawyer there, but I can surely get one there for you if you want. Or if you want to take care of this, I'll give you time served. Tell me what you want to do.
I want to take care of it, Your Honor.
Raise your right hand, sir. Raise your right hand. Do you solemnly swear the testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
Put your hand down, sir, and please tell me your name.
Michelle Vargas.
Mr. Vargas, it's my understanding you want to change your plea from not guilty to no contest. Is that right?
Yes, Your Honor.
Anybody forcing you to do that?
No, Your Honor.
Anybody promise you anything to get you to do that?
No, Your Honor.
Sir, are you under the influence of any alcohol or drugs so you don't understand what's going on here today?
No, I'm not.
Understand if you're not a citizen, this plea will subject you to deportation.
Yes, I do.
I find that it's a knowing, intelligent, and voluntary waiver, factual basis based on the notice to appear in the probable cause affidavit. At this point in time, you're going to be adjudicated guilty, sentenced to time served. $100 in court costs. I'm going to give you a year to pay. Sir, good luck to you.
Thank you.
You're welcome. Adriatic Duralaro.
Coming up here, he's here at main judge. Hi, Judge.
Sir, good morning. Sir, you've been charged with 3 municipal ordinances. It looks like I'm going to find that, hang on, give me a minute. I'm going to find that there's probable cause. It looks like the charges are trespass, resisting, and disorderly conduct. You want to resolve these? I'll give you time served.
You know, I was at a podiatrist.
All right, so let's do this. Don't tell me anything. I don't want you to tell. I don't want you to tell me. Shh, 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 shh. Sir, don't talk. Don't talk. Don't talk. Okay? Anything you say can be used against you. Don't talk. I want to appoint whoever handles the Fort
Gerald
Lauderdale
McLawrence, Your Honor.
cases. Mr. McLawrence, bond is set in the amount of $100 on count 1, $100 on count 2, $100 on count 3. Stephen Michael Mike. Oh, you're bonded out. Did you know that? Somebody bonded you out. Do you know that?
For 100.
Just 100? I'm going to ROR him on counts 2 and on 1 and 2 then.
Thank you, Judge.
You're welcome. You're welcome. Yeah, I'm still going to appoint McLawrence.
Okay.
Stephen Mike. Yeah?
I'm being informed one of the gentlemen later down is going to require Creole interpreters.
All right, so we're going to need a Creole interpreter. Thank you. Stephen Michael Mike Korick.
I have been advised it's a medical reset, Judge.
All right. Isaiah King.
Isaiah King? Isaiah King.
All right, Mr. King, good morning. Sir, you've been charged with petty theft, a second offense. There's a warrant out for your arrest. I find there's probable cause. Bond is set in the amount of $1,500. Robert Williams. Where's Mr. Williams?
Is this ammo?
Mr. Williams, good morning. Sir, you have 2 warrants out for your arrest. They look like they're both municipal ordinances. I find that there's probable cause. You want to resolve these? I'll give you time served, or else I'll get you a lawyer. What do you want to do?
Time served.
Raise your right hand. Do you solemnly swear the testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
Absolutely, ma'am.
Put your hand down, sir, and tell me your name.
Robert Warren Williams III.
Mr. Williams, it's my understanding you want to change your plea from not guilty to no contest. Is that right?
Yes, ma'am.
Anybody forcing you to do that?
No, ma'am.
Anybody promise you anything to get you to do that?
No, ma'am.
Sir, are you under the influence of any alcohol or drugs so you don't understand what's going on here today?
No, ma'am.
Understand if you're not a citizen, this plea will subject you to deportation.
Yes, ma'am.
I find that it's a knowing, intelligent, and voluntary waiver. Factual basis based on the notices to appear and the probable cause affidavit. At this point in time, in reference to both cases, you're going to be adjudicated guilty, sentenced to time served concurrently, $50 cost on each. I'm going to give you a year to pay. Sir, good luck to you.
Thank you, ma'am.
You're welcome. Ian Lopez. Thank you. Mr. Lopez, you've been charged with battery. I find there's probable cause. Bond is set in the amount of $1,000. No contact with the victim. Frank, yes?
Mr. Lopez, I believe if the state can verify, this is his first arrest ever. He's 21 years old. He's been living in our community his whole entire life. He lives in Tamarack. Judge, he's currently, he lives with his mom. His mom is the only person that can bond him out, but she collects disability. Considering this is his first offense ever, would you consider pretrial release, or in the alternative, reducing the bond from $1,000 to $500?
I'll reduce the bond from $1,000 to $500.
Thank you, Judge.
You're welcome. Frank Williams. Mr. Williams, good morning. Sir, you've been charged with, there's a case out for your arrest. It's for an open container. I find there's probable cause. You want to take care of this? I'll give you time served.
Yes, ma'am.
Raise your right hand. Do you solemnly swear the testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
Yes, ma'am.
Put your hand down, sir. Please tell me your name.
Frank Williams.
Mr. Williams, it's my understanding you want to change your plea from not guilty to no contest. Is that right?
Yes, ma'am.
Anybody forcing you to do that?
No, ma'am.
Anybody promise you anything to get you to do that?
No, ma'am.
Sir, are you under the influence of any alcohol or drugs so you don't understand what's going on here today?
No, ma'am.
Understand if you're not a citizen, this plea will subject you to deportation.
Yes, ma'am.
I find that it's a knowing, intelligent, and voluntary waiver. Factual basis based on the notice to appear on probable cause affidavit. At this point in time, you're going to be adjudicated guilty, sentenced to time served. $50 in costs. I'm going to give you a year to pay, sir. Good luck to you.
All right, thank you, ma'am.
You're welcome. Muhammad Azmam. Mr.
Azim is here at Main, Judge.
We reset this from yesterday.
That is correct, Judge. It's a misdemeanor offense. I believe it's a trespass. I'm not too entirely sure. I tried to speak with Mr. Azim yesterday. I tried to speak to him again today. I believe there may be potential mental health issues. Judge, I'd ask you to, even though it's a case, I'd consider asking you if you would R1 Mr. Azim.
I'm going to set this. It's set in front of, on 6/19 at 1:30. I'm going to set it in front of the division judge. That I don't know who the division judge is, but let's set it there, and let's have them send him to mental health if that's what he needs.
Yeah, and Your Honor, just so you know, I checked that. It looks like he was before Judge Lerner ran in this case before, but she recused herself.
Okay. It looks like he was before Judge Lerner ran, and she's no longer the judge handling the case.
She recused herself?
She
We
probably
can't set it
said.
in front of her.
No, we're going to set it in front of the division judge. Set it in front of the division judge.
Thank you, Judge.
You're welcome. Robert Wayne Darrington.
Thank you. Robert Darrington?
He-
Oh, is he in the jail?
What? Where is he?
Conti.
All right, I need that back. Good morning, sir.
Good morning.
Sir, you've been charged with criminal mischief, 2 counts, and giving false information to a police officer.
Your Honor, actually, you'd actually reset this for Thursday. You asked me to get in touch with the victim.
Right.
Your Honor, I spoke with Ms. Hill. I've actually printed out and provided both defense counsel and Your Honor copies of not only Ms. Hill's petition for injunction, but also another woman's sworn petition for injunction. Ms. Hill is very concerned for her safety and well-being. I have no offer for Mr. Darrington. There's the possibility this will be explored for additional charges, and I do. And the additional reason I printed out those petitions, Your Honor, in case I don't know if there was going to be any kind of reconsideration of bond. I do believe Mr. Darrington poses a risk to the community.
What are you asking for?
Well, Your Honor set the bonds at $500 apiece on counts 1 and 2 and $100 on 3. I don't know that I can really ask the court for any modification.
Court finds there's probable cause. Bond is set in the amount of $500 count 1, $500 count 2, $100 count 3. No contact with the victim. Okay, good.
I wouldn't say anything else if I were you, because there's a real chance your bond is going to go through the roof if you do. So try and bond out, all right, Robert?
Anthony Thomas Mack.
Yes, Mr. Anthony Mack is here present for the main.
All right, it looks like these are 2 additional charges, counts 10 and 11. Court finds there's probable cause. Bond is set in the amount of $25,000 on count 1 and $1,000, well, count 10 and $1,000 on count 11.
Judge, I know he's being held on other matters and he currently can't afford that, but I'd ask you to take his financial resources into account. He's not employed. He's been in custody for about over 30 days. He is homeless. He has no money in the bank, no property. He's financially indigent. Would you consider reducing the bond set on the burglary charge?
Counsel for the state, what is the bond on counts 1 through 9?
His total bond, Your Honor, $7,025. He's being held on 5 other burglaries.
What are the bond? Are they 7,000 total?
Yes, spread them. When you add them all up, that's what it is.
All right. Can I? Instead of $25,000, I'll set the bond at $15,000.
Thank you, Judge.
You're welcome. Quentin Jashad Jackson.
Jackson's a medical reset.
Roy Lee Addison.
Dandy reset. When you see 3 and 4.
Mr. Addison, good morning, sir. Sir, you've been charged with grand theft and uttering a false instrument. Court finds that there's probable cause. Bond is set in the amount of $1,000 on counts 1 and counts 2. 3 and 4, I'm sorry.
He's got a $1,000 bond on count 1 as well.
Okay. Jordan Denorv LaFleur.
Is here present at main, Judge?
Good morning, sir. Sir, you've been charged with possession of cannabis, and there's an out-of-county hold. Court finds there's probable cause. In reference to the possession of cannabis case, bond is set in the amount of $100. No bond on count 2. Mr. Romero, does he want to resolve that?
My understanding, Mr. LaFleur, I believe someone already may have posted his bond.
Okay.
Post bond and then go to the out-of-county.
All righty.
Thank you.
Alejandro Gonzalez.
Mr. Gonzalez, come on up, please.
Mr. Gonzalez, you're in a violation of parole. Court finds there's probable cause, no bond. Mark Cross.
Mr. Cross?
Mr. Cross, good morning, sir.
Good morning.
Sir, you're in on a violation of parole. I find that there's probable cause. Bond is set in the amount of no bond. Orithith Joseph.
Mr. Joseph, come on up, please.
Mr. Joseph, good morning, sir. Sir, you've been charged with trafficking in cocaine, possession with intent to deliver cocaine, possession of drug paraphernalia. Court finds there's probable cause. Bond is set in the amount of $75,000 on count 1, $2,500 on count 2, $100 on count 3.
Judge,
yes?
Mr. Joseph, he's been residing in South Florida for like 28 years old. At this time, he's unemployed. He was previously working at Boca Resort, prepping things such as events that came through that community. He lives in Delray Beach. He's been residing in the same location with his mother for over 17 years. Financially, he has no money, bank, no property. The only person that could potentially post a bond is his mother, and she's a cook at a restaurant. So his financial resources are limited. Considering that, would you consider reducing the bond on count one from $75,000 to $25,000?
Counsel for the state.
Your Honor, the state would be requesting that the court keep the convenience bond in place. First off, if convicted of this charge, he faces a minimum mandatory prison sentence. Additionally, in October 2016 in Palm Beach, he was picked up for violating his release conditions, and that was on a delivery of heroin case that he ultimately was convicted of. He also was picked up in Palm Beach in January of last year for failing to appear in court.
The motion will be denied. Devontae Boyd. Mr. Boyd, good morning, sir. Sir, you were picked up on a violation of community control. I find there's probable cause, no bond. You'll be in front of your regular judge on 6/19. Pernell Atwell.
Mr. Atwell is coming up, Judge. He declined to serve as the public defender.
All right, Mr. Atwell, it looks like you were picked up on failing to register as a career offender. Hang on. Court finds there's probable cause. Counsel for the state, what's your recommendation on bond?
Your Honor, did pretrial have some information to provide? Oh.
Case 17-10858 TC10A.
Okay. Counsel.
17-10858. We're going to ask that this pretrial status be revoked.
At this point in time, his pretrial status will be revoked. Bond is set in the amount of $15,000. No bond on the pretrial.
Judge, what was the case number you revoked this release on?
17010858 TC10A.
And what was the bond set on this case?
15,000. Christopherson Nelson Bale. Go ahead. I'm sorry, Mr. Romero. That's okay.
He told me at the last second that he did sign up with the public defenders. He just told me that his only source of income is he's on disability. So it is a fixed income. A judge considering that would consider reducing the bond on the case before you, even though on the other case it's going to be held no bond.
To what?
How much you get in disability a month? 661, 10%. Hopefully you see it. I'd ask you to consider $6,000.
Counsel for the state.
Your Honor, I think based on his criminal history, 2001 burglary of an occupied dwelling. He was PRR qualified. He was habitual offender qualified. He's had multiple burglary dwellings in his past. When he's out on a small matter, he's violating his release conditions. I think the $15,000 bond is reasonable.
Motion be denied.
Your Honor, I'm
Christopherson
told we
Nelson
need a
Bailey.
Creole interpreter, and the Creole interpreter is present.
On who?
I don't know.
Who?
But they're going to tell us very soon.
All right.
Who was the Creole? Mr. Sentinel, I believe he's on page 15.
All right, let's handle Mr. Bailey first since he's standing in front of you, okay?
Yes, sir.
Mr. Bailey, good morning, sir. Sir, you've been charged with grand theft auto, possession of THC, possession of cocaine, and possession of cannabis under 20 grams. I find there's probable cause. Priors, counsel for the state.
Yes, Your Honor. Mr. Bailey. As far as his DOC history, 2005 out of Monroe County, aggravated battery with a deadly weapon. He was sentenced in October 2011 to 2.5 years state prison. Showing, a moment, Your Honor. Got a hit out of the state of Ohio. I'm just checking to see what that is. It's not showing anything specific, Your Honor.
Okay. Bond is set in the amount of $1,000 on count 1, $1,000 on count 2, $1,000 on count 3, $100 on count 4. The Creole gentleman, what's his name again? I'm sorry, folks. Got it. Okay. Mr. Saint-Hill, Wisney Saint-Hill. Madam Interpreter, good morning. Good morning, sir.
Bonjour, monsieur.
Sir, you've been charged with attaching a registration or license plate not assigned.
Yo sajo avec yon
un carte identification qui pas pour,
A tag unassigned,
excuse me.
a tag unassigned, count two.
Et puis, un deuxième fois, c'est un faux tag côté gagné.
And there was a warrant out for your arrest for a probation violation.
Et puis, te gagné un papier pour arrêter ou parce que te violé probation.
I find there's probable cause.
Gen cause vraie pour yo fait ça.
Bond is set in the amount of $25 on count one,
Et premier cas, yo bon un bon de $25.
and the probation violation is a no bond hold.
Et puis, violation probation, yo pas bon aucun, pour payer aucun bon.
Thank you.
Judge, can the interpreter let him know that he'll be seeing his judge on June 20th at 8:30 a.m.?
Absolutely.
Et wapwe le juge là encore. Et what was the date again, please?
June 20th.
June 20th.
Le 20 juin et de mois ça.
Jonathan Derek Vega.
Mr. Vega's mother is present, Your Honor.
All right. All right.
Judge, Mr. Vegas here present. He declined the services of public defender, but as a friend of the court, he asked me, Your Honor, to waive formal reading of the charges he was arrested on.
Okay, at this point in time, Mr. Vega, just so you know, you've been charged with a lewd and lascivious act of the victim, 12 years old, from 12 to 16. Court finds there's probable cause. Your mom is here. Ma'am, tell me your name.
Monica Bello.
And tell me what you want to tell me.
Well, I'm here because I'm trying to help my son. This is the first time that this has happened to him. He has a good record. He is a good student, person, citizen. He recently graduated from FAU as a mechanical engineer. Part of his job that he was doing before is that really it's working with kids, with students. And he's been with Taekwondo pretty much since he was 10 years old. So he is being around kids. I mean, I'm just trying to help him. I mean, I think it's more than working with them and just playing around. I mean, I'm not trying to excuse him. I mean, probably that something like that happened, but not in any means to try to hurt or do anything that he wasn't supposed to do.
At this point in time, I'm going to find that there's probable cause. Counsel for the state.
Thank you, Your Honor. Your Honor, I spoke with Detective Deering from the Pembroke Pines Police Department yesterday. She authored the probable cause affidavit. Obviously the court's already aware this is a filed charge, so it's past the point of just mere investigation. Your Honor, the state and law enforcement are very concerned for the safety of the community, specifically minors in the community. Your Honor, I'm not going to go into the details. You've seen the PC, but it appears based on Mr. Vega's statements that it doesn't appear this is necessarily the first time something like this has happened. Your Honor, the state is going to be requesting a $50,000 bond. Not only am I going to be asking for no victim contact, but we're also going to be asking for no contact with any minors. Your Honor, at this point in time, the state's going to be requesting, should Mr. Vega post his bond, he be supervised by pretrial release with a GPS monitor, and we're going to be asking for level 1, Your Honor. I don't believe even allowing him to work at this point in time, I think, would pose too great a risk.
All right, at this point in time, bond is set in the amount of $50,000. No contact with this victim, no contact with any children. You cannot go back to your job at that karate studio. You cannot be within 500 feet of where children might be. That means a park, that means camp, that means school, that means the supermarket. If, in fact, you can post bond, it's in addition to pretrial with a GPS.
Level 1, Your Honor?
Level 1.
Thank you.
Sohab Hasan Shah.
Mr. Shaw? Mr. Shaw, come on up, please. S-H-A-H, correct?
Sir, you've been charged, good morning. You've been charged with possession with intent to sell or manufacture THC and a probation violation. I find there's probable cause. Bond is set in the amount of $1,000 on count 1, no bond on count 2. You're going to be in front of your judge on 6/19.
Thank you.
You're welcome. Alexander Jerome Smith.
Sir, President?
Mr. Smith, good morning. Sir, you've been charged with grand theft. I find there's probable cause. Bond is set in the amount of $1,000. Calvin Russell Johnson.
Mr. Johnson?
Mr. Johnson, you've been charged with criminal mischief. Court finds there's probable cause. Bond is set in the amount of $500. Jeffrey Williamson. Sir, good morning. You've been charged with a violation of parole. I find there's probable cause, no bond. Warren Darlow.
Mr. Warren Dolo is here, present judge.
Mr. Darlow, good morning. Pardon?
We'd be waiting for a reading of the charge which he was arrested on.
All right. Court finds that there's probable cause. State recommendation on a bond.
Your Honor, if I could just have 1 moment, I'm pulling his criminal history. See if he ever. Your Honor, based on the nature of the offense, state is going to be requesting a $15,000 bond. Should Mr. Darlow post his bond, we're going to ask that he be supervised by pretrial release with a GPS monitor.
All right. Sir, bond is set in the amount of $15,000. If, in fact, you can post bond, it's in addition to pretrial release, which is level 1, which is the GPS monitor.
Judge, the only additional thing I'd ask you to consider is he's 61 years old, been living here since 1977. He is a subcontractor. He works on boats. He's employed whenever someone calls him for work. Unfortunately, this season's been really slow. He told me about last month he only made $300 for the entire month. He only has $60 in the bank. He has no property. He does have family that reside in Coral Springs. His brother-in-law is a delivery driver. He's the only one that can potentially post his bond. So their financial resources are limited. I'd ask you to impose a reasonable bond considering Mr. Darlow's financial circumstances from $15,000, as you stated, to potentially $5,000 on Mr. Darlow's behalf.
Counsel for the state.
Your Honor, I believe the aggravating factors, and while I haven't gone into the specific, obviously, without even going into detail, based on his status, the court is aware that he has a prior. I think those facts are aggravating and outweigh the mitigating factors.
The motion will be denied. Isaiah Coney.
Your Honor, I'll wait till he gets up.
Here he comes.
I provided a packet to Your Honor, defense counsel. I don't know if you might want to reset it for one. It's got a victim statement, a statement that Mr. Coney gave, a supplemental report.
Want me to reset it to?
It's whatever you want to do, Judge.
Yeah, also, Judge, I've been trying to reach his mother. My
You want me to
understanding
reset
is
it to
that
1:30?
Yeah, I think.
All right, let me just reset it to 1:30.
Okay. I'm going to keep trying to reach your mother, Mr. Comey.
One thing I don't know if anyone's aware, he advised me that his family hired a private attorney.
Yeah, I'm trying to reach his mom.
Well, let's hope they can be here at 1:30.
Nobody's
also.
filed a notice of appearance yet.
Okay. You're welcome. Jordan Phillips.
Yeah, right.
Mr. Phillips, good morning. You've been charged with grand theft. I find there's probable cause. Bond is set in the amount of $1,000. James Alfred Brown.
Mr. Brown?
Mr. Brown, good morning.
Good morning.
Sir, you've been charged with grand theft auto, carrying concealed firearm, resisting without violence, fleeing or attempting to elude a law enforcement officer, and driving while your license is suspended. I find there's probable cause. Bond is set in the amount of $1,000 on count 1, $1,000 on count 2, $100 on count 3, $1,000 on count 4, and $100 on count 5. Marlon Baccaro Lee.
Judge, Mr. Brown, can you just sign a phone order?
Of course.
To his phone contacts?
Of course.
Thank you.
You're welcome. Marlon Baccaro Lee. Mr. Lee, good morning.
Good morning, Honor.
Sir, you've been charged with possession or displaying a canceled or revoked driver's license, driving while your license is suspended, a third or subsequent event. Court finds probable cause. Bond is set in the amount of $500 on count 1, $750 on count 2. Alexander Babkin.
I've been advised Alexander Batkin is a medical research judge.
Okay. Jordan Sadia Bitton.
Mr. Bennett?
Mr. Bitton, good morning.
Good morning, ma'am.
Sir, you've been charged with possession of cannabis, possession of THC, and an expired tag. I find there's probable cause. Bond is set in the amount of $1,000 on count 1, $1,000 on count 2. Nicholas Gonzalez Rodriguez.
Rogers.
It's not Gonzalez Rogers, it's just Rogers, sir?
No, it's Gonzalez Rogers.
Okay.
He said Rodriguez.
I'm sorry, sir.
It's okay.
Sir, you've been charged with a violation of probation. There was a warrant out for your arrest. I find there's probable cause. Bond is set in the amount of $500. Shane Michael Holgate.
Mr. Holgate, come on up, please.
Mr. Holgate, good morning. Sir, you've been charged with possession with intent to sell or deliver cannabis, drug paraphernalia possession, resisting without violence, and 2 probation violations in 2 different cases. Court finds there's probable cause. Bond is set in the amount of $1,000 on count 1, $500 on count 2, $500 on count 3. No bond on 4 and 5.
Judge, I'd ask you only to sign a photo with him.
Absolutely. That'll be granted. Mark Emmanuel Forcand. Good morning, sir. Sir, you've been charged with driving on a permanently revoked driver's license. I find there's probable cause. Bond is set in the amount of $1,000. Jonathan David Marty.
Mr. Markey, come on up, please.
Mr. Marty, good morning. Sir, you've been charged with aggravated battery with a deadly weapon and a probation violation where there was a warrant. I find there's probable cause. Bond is set in the amount of $1,000 on count 1, no bond count 2, no contact with the victim. Adam Shaw. Mr. Shaw, good morning. Sir, you've been charged with possession of cocaine, possession of THC, and possession of cannabis. I find there's probable cause. Bond is set in the amount of $1,000 count 1, $1,000 count 2, $100 count 3. Christopher, you're welcome, sir. Christopher Snell. Mr. Snell? Is that him? Okay, thank you. Brian Scott Steinberg. Where's Mr. Steinberg? He bonded? Thank you. Robert Edward Maddox. Mr. Maddox, good morning.
Good morning.
Sir, you had a violation of probation. I find there's probable cause, no bond. Lawton James Gillard. Thank you. Ryan Marcus Pearson. All right, Mr. Pearson, good morning, sir.
Good morning.
Sir, you've been charged with carjacking without a firearm, robbery without a firearm, robbery without a firearm, aggravated fleeing with injury, leaving the scene of a crash with damage involving property, and a capious felony robbery, no weapon.
Your Honor.
Counsel for the state.
Thank you, Judge. Your Honor, these charges have been downfiled from some of them have been downfiled from punishable by life offenses where he was being held no bond from his first appearance to bondable offenses. I printed out a copy of the original probable cause affidavit for Your Honor and defense counsel so you can see, since he's now entitled to a bond, so you can be familiar with the allegations.
Hang on one second, okay?
Yes, Judge.
Counsel for the state, what's your recommendation?
Your Honor, just to advise the court, in addition to this offense, Mr. Pearson has an open burglary of a structure before Judge Bailey. Based on the allegations in this case, Your Honor, the level of violence, I'm going to be requesting a $50,000 bond on count 1. $25,000 bonds on counts 2, 3, and 10, $10,000 on 4. And should Mr. Pearson post his bond, I'd ask that he be supervised by pretrial release with a GPS monitor.
You have one more. Count 5.
Well, I'm fine with that bond being left at 100, Your Honor.
Counsel for the defense.
Judge, in speaking of Mr. Pearson, he's 32 years old. He actually resides in Daytona Beach. He's been in custody now for quite some time, I believe over 30 days. He was a plumber by trade. He got injured on the job, so he's receiving workman's compensation. He gets about $350 per week. He lives with his fiance in Daytona Beach. Their monthly rent is about $900. The person that he's going to contact to help post his bond is his parents, who reside in Daytona. His father is a plumber, and his mom is a stay-at-home wife. So their resources are limited to what the dad makes as a plumber. What the state is asking as far as their bond, financial possibilities is out of reach, Judge. I would ask you to consider setting a bond on count 1 of $20,000, on count 2 of $5,000, count 3 $5,000, and count 4 $5,000. So it would be a total of, I believe if my math is correct, we'd be asking for a total of $25,000.
I think your math might not be correct, because I think what you're asking me for is $35,000, but that's okay. Counsel for the state.
Your Honor, well, and I just would want to bring to the court's attention, just because it's been mentioned how long Mr. Pearson's been in custody. This was filed, this case was filed May 30th. I don't know why it took so long for him to get back in first appearance on the change of charge, but it was filed before, there was actually a motion for release where it was filed by that point.
All right. Court finds there's probable cause. Bond is set in the amount of $25,000 on count 1, $15,000 on count 2, $15,000 on count 3, $10,000 on count 4, $100 on count 5, and $25,000 on count 6.
Your Honor, I'm sorry, as far as...
No contact with the victim. If
Well,
in fact he bonds out, what do you want, level 1 or level 2?
Your Honor, I'd be asking for level 1.
Level 1 GPS TAD.
Judge, my only additional concern is, like I advised the court, he lives in Daytona Beach. If he's placed on level 1, that means he can't go and live with his family, where he lives.
And when he was arrested, he's showing a Deerfield Beach address, Your Honor, and that
Okay, he's showing a local address of Deerfield Beach. So,
Like 6 months ago.
all right.
When he was arrested, I guess that was a previous address where he lived 6 months ago, but now he's residing in Daytona Beach.
And Your Honor, I
There's
guess,
no residence here in Broward County.
Your Honor, if there's a concern regarding the safety of the community, I don't see why people that happen to live in other counties and come into Broward County to commit a crime should be able to avoid having to have a GPS.
That'll be denied. Yes. Yeah. No, I want just the level 1 GPS. Sorry. No. You meet Yakimo Williams.
Your Honor, I provided paperwork in this case.
Mr. Williams, good morning, sir.
When Mr. Williams first came through on first appearance, it shows, and I provided the court with a copy of the original information, Judge Gottlieb's findings, and the original warrant. The reason it's here in a change of charge is he was booked for murder because there's no statute for attempted murder, but you can see on the comment section the warrant is attempted murder. Judge Gottlieb found proof evident presumption grade and ordered him to be held no bond for attempted murder, which is the offense we filed. We would just ask the court to adopt Judge Gottlieb's findings and order him to be held no bond.
Counsel for the defense.
Well, Judge, I think that the decision whether or not to hold Mr. Williams without bond is up to you. The case is currently before you. And I would ask that this court conduct an Arthur hearing. And our position would be that based on what's been submitted to this court so far, this court cannot make a determination that the proof is evident or the presumption is great. That is the highest standard we have in criminal law, higher even than proof beyond it to the exclusion of each and every reasonable doubt. At this point in time, the state has provided no evidence to this court. They've called no witnesses. They've introduced no physical evidence. They're relying on a document that is designed to establish probable cause to establish proof evident presumption great. Our position is that that court cannot be done, and this court should set bond for Mr. Williams.
Counsel for the state, anything further?
Just noting again that Judge Gottlieb already found proof evident for attempted murder.
Okay. At this point in time, in reference to count 1 and count 4, I find there's probable cause. In reference to the attempted first-degree murder, bond is set in the amount of no bond. Let the record reflect that I'm looking at the information that's been filed along with the affidavit to arrest. I'm finding the proof is evident, presumption is great. In reference to count 4, bond is set in the amount of $1,000.
I guess it's also worth noting he has a violation of probation holding him no bond as well. So.
Okay. All right, what else do we have, folks? We done?
I believe so, yes.
I think so, too.